folks. We're back again with our third of 4 installments of the Institutions of U.S. Government, the Judicial Branch. I am Ms. Jennifer Blank, and I will be your guide on this journey. So, as before, we are going to start out with a review of the branches of government, lest we forget them, right? So, legislative branch, which is Congress, executive is the president, judicial branch is the Supreme Court, and the unofficial fourth branch, the bureaucracy. All right, so the legislative makes law, the executive executes and enforces law, judicial branch judges law, and the unofficial fourth branch, the bureaucracy, creates regulations that help this enforcement of law. And it does this based on the instructions of both the executive and legislative branches. Here, for your viewing pleasure or your reviewing pleasure, we have a review of checks and balances and separation of powers. Please learn it, memorize it, understand it. And then, of course, we have divided government. We've talked about this before, but legislative and executive branches are inherently political branches, right? There's a lot of politics involved. The judicial branch is supposed to be apolitical. It's supposed to be neutral or objective. And now, let's get to the brass tacks. Let's look at Supreme Court. So, what cases actually go to the court? What cases actually get there, right? So when two lower courts are in disagreement, the Supreme Court can be called upon to settle the dispute. When a lower court's ruling conflicts with an existing Supreme Court ruling, the Supreme Court will either reaffirm their ruling or side with the lower court. When a case has broad significance, something that is going to have national impact, that's when the Supreme Court's going to call for the case. Now, issues of desegregation, issues of abortion, the election of 2000, the Bush v. Gore case when we didn't know who the president was going to be, that obviously had national significance. The court immediately called for the case, the Supreme Court, that is. When a state court has decided a substantial federal question, the Supreme Court will call for that case so they can settle that federal question. Then here are some additional instances. When the highest state court holds a federal law invalid, or upholds a state law that has been challenged as violating a federal law. In those two instances, the Supreme Court has to settle the disagreement. When a federal court holds an act of Congress unconstitutional, the Supreme Court has to settle that. And when the Solicitor General, who is a political individual representing the legal interests of U.S. government, officially like the number one lawyer, when that person pressures the court to hear a case, sometimes they will give in to that and they will take the case. So cases before the court, what happens if you want to get before there? So that they grant petitions for review, right? So that's what you need to have happen. This review is granted by something called a writ of certiorari, okay? So this writ is only issued when 4 justices agree. So this is known as the rule of 4. So 4 justices have to vote to hear the case. If you don't get 4 justices voting for it, then the case isn't heard before the court. And as I said in a previous video lesson, the court only hears about 1% of those petitions brought before it. There are literally thousands of cases, and 9 justices cannot hear all these cases. So they only take the top 1% that are the most significant for federal law and of national importance. Once the court has decided to accept the case, both parties in the case have to submit legal briefs, legal written documents. And after they submit those briefs, the justices will take time studying them, looking at them, coming up with their own arguments for and against, and then those involved in the case will come before the court and make oral arguments, at which point they will be questioned by each of the justices. If the court is unanimous, if all of them vote one way on the case, then one justice will write the opinion of the court. It's usually the Chief Justice, but it doesn't have to be. Tradition usually is the Chief Justice who does it, but not always. If the justices are divided, then there will be a majority opinion and there will be dissenting opinions. So justices who voted against the majority will write their own opinions as to why they objected, why they dissented. The majority opinion reflects the reviews of the judges. You have the unanimous opinion where all justices agree, right? A dissenting opinion, like I said, is prepared separately to describe an opinion of one or more justices in disagreement with the majority. You can have multiple dissenting opinions. So maybe 2 justices both disagree with the majority, but they disagree for different reasons. In that case, they would each write their own dissenting opinion outlining their individual reasons for disagreement. A concurring opinion is prepared by a justice who agrees with the majority, but maybe for slightly different reasons, or wants to highlight or make clear a particular point that maybe wasn't taking center stage in the majority opinion. Now, that is it for part 3. I will see you folks in the next video, where we will talk about some important vocab and policy making in the courts.